Dr. Wagner is an independent researcher and writer based in Edmonton, Alberta. His PhD is in political science from the University of Alberta, and together with his wife, he has homeschooled their 11 children. Dr. Wagner's work... Yeah, go ahead. That's commendable. Amen. Dr. Wagner focuses on conservative perspectives and has been the author of several books, including Canada, Standing on Guard for Thee, as well as The Anglosphere's Broken Covenant. You can find his writings and his articles and his interviews online in many different places, and I'm sure he'll share with us some of the best places to go to get those resources. But please join me in welcoming Dr. Michael Wagner.
Thank you. Thank you, Ryan, and thank you to Stephen and the Cántaro Institute for inviting me to speak. It's been great to be here. I've met some people I've known online for several years and got to meet them in person coming here, and also, to meet some new friends, so it's great to be here. Okay, so I'm going to be talking today about two main points. One is that Canada was historically a Christian country, and secondly, that the adoption of the Charter of Rights and Freedoms in 1982 turned Canada away from its original Christian worldview foundation. Now, the Charter of Rights is part of Canada's Constitution, so it's a major feature of Canada's political system. It was added to the Constitution in 1982 when the Constitution was repatriated from Britain. So the Charter is not the Constitution in and of itself. It's part of the Constitution. Most of the Constitution actually deals with federal and provincial responsibilities. So most of the Constitution deals with how governments relate to each other. The Charter of Rights deals with how the government relates to us as citizens and as individuals. It's very important that Christians understand the impact of the Charter on Canada's Christian heritage. Now, many people appreciate the fact that Canada was founded as a Christian country and that its Christian character has been eroding for the last few decades. Needless to say, there are many factors, religious, cultural, and political, that have contributed to the erosion of Canada's Christian foundation. But the Charter itself is one of the significant factors. The Charter has had a pronounced effect in diminishing the role of Christianity in Canadian political life. The Charter has pushed Christianity to the sidelines of Canadian political life. The Charter is not a neutral document. It is grounded on a particular worldview and is not a Christian worldview. I prefer to call that worldview secular humanism or secularism. Others might want to use a different term for that, but it doesn't really matter. What matters is the understanding that the worldview has changed. Whatever the case, adopting the Charter imported into the Canadian Constitution a new frame of reference for public policy. Christianity was being replaced by a secular perspective. I'll use three examples to demonstrate this point. First of all, it was because of the Charter that Canada's Lord's Day Act was struck down by the Supreme Court in 1985. Secondly, it was because of the Charter that Christian elements in education were expelled from public schools in court decisions in 1988 and 1990. And thirdly, it was because of the Charter that Canada's Christian definition of marriage was declared to be unconstitutional by the Ontario Court of Appeal in the year 2003. Canada had had an explicitly Christian definition of marriage until the year 2003. Now, in all of these cases and others that I'm not mentioning, the Charter was the reason for eliminating the Christian influence in political affairs. Now, Canada was founded as a Christian nation and continued as a Christian nation for most of its history. Now, that's not to say that most Canadians have been Christian. Like, when I say Canada is a Christian country, I don't mean that most Canadians are Christians in a biblical sense or have been Christians. I'm not talking about how many people or what percentage of the population was Christian. I'm talking about the worldview that was the foundation of our political system. In a general sense, the worldview underlying Canada's political system was Christianity until, from the time of first settlement of Europeans until 1982. So all political systems in every country, every political system is founded on a particular worldview. So ours was originally a Christian worldview. So if it wasn't a Christian worldview, it would be a different worldview, but every country is based upon a particular worldview. There is no such thing as a neutral worldview or a neutral foundation for a country or a political system. Now, the idea that Canada has historically been a Christian country, should not be controversial. This is something that's recognized even by contemporary historians. For example, University of Toronto historian John Moyer, in 1980, he wrote, "At least until a generation ago, it was confidently assumed by most Canadians that Canada was a Christian country and that this was God's providential intention." So we can find many historians talking about the fact that Canada was historically a Christian country. But even more important than some of the historians are some of the founders of Canada talked about this. In 1876, 1927, there was a discussion in the House of Commons about whether there'd be prayers read at the beginning of each day in the House of Commons. And one of the persons who spoke in favor of having prayers read in the House of Commons was Sir John A. Macdonald, our first Prime Minister. And the Hansard says this, it says, Sir John A. Macdonald, quote, felt as a body composed of representatives of a Christian country and supposed to be Christians themselves, that it was quite proper that the blessing of the Almighty should be invoked upon the acts of the legislature. So the man who's considered to be most responsible for Canada's confederation explicitly said in the House of Commons that Canada was a Christian country. Now, Canada, as we know it, was established as a colony of Britain, and Britain's political system and legal system were essentially transplanted to Canada. Now, because Britain itself at that time was an explicitly Christian country, it was only natural that many of Britain's Christian characteristics would be incorporated into Canada right from the very beginning. So among British legislation was, Britain had legislation protecting the Lord's Day, Sunday, as a day of rest as in the Christian tradition. And so when Britain founded Canada, the British colonies here in North America, they also carried over those laws protecting the Lord's Day at a colonial level. Each colony had laws protecting the Lord's Day. So when Confederation happened, though, the responsibility for that kind of legislation actually was elevated to the federal level. Nevertheless, those laws were left at a provincial level. So first we still had, even though it became a federal responsibility, it was the provinces themselves that still had legislation protecting the Lord's Day. So that was a problem because the provinces didn't have that jurisdiction anymore. So back in those days, there was a lot of conflict with the railways over Lord's Day legislation because railways wanted to run on the Lord's Day. So to make a long story short, a court case was initiated against Ontario's Lord's Day legislation, and it went all the way up to the Judicial Committee of the Privy Council. Now, the Judicial Committee of the Privy Council was like the highest court in the British Empire and was Canada's highest court of appeal until 1949. Like the Supreme Court of Canada was created in 1875, but for many years thereafter, you could still appeal beyond the Canadian Supreme Court up to the JCPC in London, England. So this case in 1903 went to the JCPC, which ruled that Ontario's Lord's Day Act was invalid because it was impinging on federal responsibility. So all of the Lord's Day legislation at the provincial level in Canada at that time in 1903 was invalidated by the JCPC. So Canada was going to need federal legislation to protect the Lord's Day if it was going to have any protection at all. So in March 1906, the government of Prime Minister Wilfrid Laurier introduced legislation into the House of Commons to have a Lord's Day bill. And it was very controversial because, again, the railways didn't want Lord's Day legislation, and Quebec didn't like it very much either. Now, in the debates over this bill in Parliament, a number of politicians referred to Canada as a Christian country, and I'm just going to read a couple of quotes here. One senator, Senator James McMullen from Ontario, on July 9th, 1906, he said this, "I have no desire whatever to trample upon the conscientious convictions of any other individual or any other province, but we must not forget that we claim to be a Christian nation, and we are a Christian professing nation at least, and as such we should respect the laws of God. We generally make our laws in accordance with the provisions of God's law." Then a couple of days later, Senator William Ross of Nova Scotia said this in the Senate, "Now the individual or the family, the community, province, or the dominion which observes the Sabbath day as it should be observed is the one that will prosper. And if we are to enter upon the downgrade by setting at defiance the fourth commandment, we will go down as a nation by doing so." So he's saying if we don't adopt Lord's Day legislation, our nation will go down. It was just assumed by Canadians and Canadian politicians that Canada was a Christian country. So you can find these kinds of quotes. And as a Christian country, it was natural that we would enshrine the fourth commandment in some sense in our legislation to protect the Lord's Day. So the Lord's Day bill was introduced, as I said, in March 1906, and it received royal assent in July later that year. Now, support for the Lord's Day Act began to decline in Canada. One of the reasons was during World War I, the government suspended the Lord's Day Act, right? You can't have people rest on the Lord's Day during the war. I mean, the war is like 7 days a week, right? So for 4 years, people got used to the living, or doing their regular lifestyle things on Lord's Day because it was suspended for those 4 years. So they began to, be loosened from their Lord's Day commitments. Then, of course, during World War II, for 6 years, again, the government suspended the Lord's Day Act. So by the end of World War II, in particular, support for the Lord's Day was eroding among Canada's population because people were used to doing whatever they wanted on the Lord's Day. Now, ultimately, this case would go to the Supreme Court of Canada. In 1960, Prime Minister John Diefenbaker brought in the Canadian Bill of Rights. Now, the Bill of Rights was just a piece of federal legislation. It only applied to the federal government, but it did have a freedom of religion provision. Now, there's two guys, Walter Robertson and Fred Rosatani. They operated a bowling alley in Hamilton, and they kept it open on Sunday. So they were charged under the Lord's Day Act, and their case went all the way to the Supreme Court of Canada, and they challenged the Lord's Day Act on the basis of the freedom of religion in the Canadian Bill of Rights. But interestingly, the Supreme Court of Canada rejected their argument because because they interpreted Canada's Lord's Day legislation in terms of Canada's history. That is, Canada has always had Lord's Day legislation, and so Canada's concept of freedom of religion could not be in conflict with the idea of Canada's Lord's Day legislation. Actually, this is what they wrote in their decision against Robertson and Rosatani. Legislation for the preservation of the sanctity of Sunday has existed in this country from the earliest times and has at least since 1903 been regarded as a part of the criminal law in its widest sense. Historically, such legislation has never been considered as an interference with the kind of freedom of religion guaranteed by the Canadian Bill of Rights. So Robertson and Rosatani were out of luck because Canada's Bill of Rights was being interpreted in light of Canada's Christian history. But then came Pierre Trudeau. Now, Pierre Trudeau was first elected. I guess this is someone you've obviously heard of before. Pierre Trudeau was elected as a Liberal in 1965, and he was made Minister of Justice in 1967. And as Minister of Justice, he prepared a proposal for a Bill of Rights to be entrenched in the Constitution of Canada. And actually, that proposal was published by the Canadian government. So this is Pierre Trudeau's original proposal for this Charter of Rights, a Canadian Charter of Human Rights by the Honourable Pierre Elliott Trudeau, Minister of Justice. This is published by the Government of Canada, and the preface is by Prime Minister Lester Pearson. So basically, Trudeau was arguing that without having entrenched rights in our Constitution, that we weren't properly protected. Like our rights as Canadians were vulnerable because they weren't entrenched in the Constitution like they were in some other countries. I think that's kind of a red herring, because when you look at Canada in 1968, when this is written, Canada took second place to no other country in its protection of individual rights. Canada is not perfect, and there's been various, peoples have had their rights violated over the years and stuff. But when you think of 1968, what country in the world had better protections for rights than Canada did? There weren't any ones that were obviously better than Canada. We were as good as it gets, and yet Trudeau was saying, well, we need to fix this with something in the Constitution. Now, one of the things that is very important about this adoption of the Charter of Rights was it was changing Canada's constitutional system from what was called legislative supremacy to what some of us call judicial supremacy. Now, legislative supremacy meant, or parliamentary supremacy, that elected officials have the final say on political issues in Canada. And that's the British system, and that's the way Canada's system was until the adoption of the Charter. The final say would be elected officials. Now, Trudeau wanted to transfer that by adopting the Charter. We would make judges the final decision, as the final decision makers for many of our public policy decisions. And he said that explicitly in his book. That's one thing about Trudeau. I don't like Trudeau, but he was honest. When he told us he wanted to make changes, he would tell us, right? So in this book, he says this: an entrenched Bill of Rights would offer constitutional protection, although at the price of some restriction on the theory of legislative supremacy. It is suggested that this is not too high a price to pay. So it's kind of an understated way of saying it, but he's being honest. We're going to pay the price of moving away from legislative supremacy to judicial supremacy. And he was willing to pay that price, of course. Now, the Lord's Day Act is the perfect piece of legislation for demonstrating how the Charter has changed Canada. As I mentioned previously, in 1963, the Lord's Day Act was challenged at the Supreme Court of Canada. The Supreme Court of Canada said, the Lord's Day Act is perfectly consistent with our Constitution. But then after the Charter was adopted, it would be challenged again, and this time the Lord's Day Act would be struck down because of the adoption of the Charter. So on Sunday, May 30th, 1982, Big M Drug Mart in Calgary was opened in violation of the Lord's Day Act, and they were charged. And to make a long story short, that case went all the way to the Supreme Court of Canada. The Supreme Court struck down the Lord's Day Act as being in violation of the Charter's view of freedom of religion and freedom of conscience, because the Lord's Day Act was a specifically Christian piece of legislation. And with the Charter, the Supreme Court ruled we could no longer have specifically Christian pieces of legislation. We were no longer to interpret rights in Canada's Constitution in light of Canada's Christian heritage. We're going to be starting something new with a secular perspective. So previous court decisions, like that Rosatani and Robertson decision, was no longer relevant in Canada. Even though it was a Supreme Court decision, it was no longer relevant because we'd bring in the Charter, we'd fundamentally changed our Constitution. So under the Charter, laws compelling a day of rest for religious reasons were absolutely forbidden. And there's something also that's really, really important about this decision. They said that the Supreme Court said the mention of God in the Charter's preamble has no bearing on Charter interpretation. I know a lot of Christians like the Charter because it mentions God in the preamble, but the Supreme Court says that has no impact on the interpretation of the Charter. And actually, I'm going to get to that later on, but let me just say what the Supreme Court said about that preamble in this decision. They said this: the evolution of Canada as a pluralistic multicultural society, as well as the reference to God, rather than to an identifiably Christian conception of God, can have no bearing either on the characterization of laws aimed at enforcing specifically Christian observances, nor in the classification of such legislation as being within Parliament's criminal law power. So this decision struck down the Lord's Day Act, but it did much more than that. This was the first major Supreme Court decision under the Charter on freedom of religion issues. So this would be the precedent that we used for future decisions to do with freedom of religion issues, Charter interpretations of that in future in Canada. So it was a groundbreaking decision, in other words, because decisions since that time often refer to the Big M drug mart decision. So, and not only that, but by striking down Canada's Lord's Day Act, it actually kind of diminished the Lord's Day in the eyes of many Canadians, and even many Christians, no longer pay much attention to the Lord's Day because it's not part of our culture anymore as a result of this being struck down. Okay, so I mentioned I was going to do 3 examples. The first example was the Lord's Day Act. Now I'm going to talk about Christianity in Ontario public schools. Of course, Ontario is our biggest province, our most influential province, and what's also important to understand is in Canada, because education is a provincial responsibility, there's like no Canadian national history of education. There's 10 provincial histories of education that each one is very different from the other. Quebec especially is different, Newfoundland is different. Some in the West have some similarities, but generally speaking, each of the histories of education is very different for the provinces. Now, education is the way that a community passes on its cultural heritage to subsequent generations. So it's possible to determine what is important to a community by looking at its education system, what is taught, and so on. If a particular religion is taught to the exclusion of all other religions, it's probably safe to conclude that that religion is integral to the community. Now, with this in mind, it's important to note that until the late 1980s, Christianity was an explicit part of the public education system of Ontario. So Christian practices and teachings were part of Ontario's public education system right from the early 1800s and right through to the 1980s. Now, there are 2 components of the religious activities in public education. First, there's the what are called exercises, like religious exercises, like opening or closing the school day with Bible reading and prayer. That's the religious exercises. And then there's explicit religious instruction. So those two components. And it's important to recognize those distinctions because they were struck down in separate court decisions, one in 1988 and one in 1990. Now, it's also important to recognize, although the Ontario's public school regulations mandated religious exercises and religious instruction, they weren't always followed in all the public schools. Over time, fewer and fewer public schools were actually following these practices, especially in the bigger cities, but they are more common in the rural areas to still have religious exercises and religious instruction. Now, by the 1960s, the Christian influence in Ontario's public education system began to be less and less popular within the population. There's more opposition to Christian influences in the Ontario public school system. And so in January 1966, the Ontario provincial government appointed the Committee on Religious Education in the Public Schools of the Province of Ontario to study this problem. It was headed by Carler McKay, so it's commonly known as the McKay Committee. So this is established in January 1966 to study Christianity in Ontario's public schools, a government committee. So the government committee, the McKay Committee, released its report in 1969, 3 years later, recommending that Christian instruction be removed from Ontario's public system. I just want to quote a paragraph from that report, because this quote from the committee's report really gives you the idea of how much Christian influence there was in Ontario's public schools. So this is a bit of a lengthy quote, but just bear with me and listen for the word Christian and Christianity in this quote. The Schools Administration Act states that it is the duty of the teachers to inculcate by precept and example respect for religion and the principles of Christian morality. This material, much of which is definitely Christian and Protestant in content, is in our opinion a vehicle leading to religious commitment rather than to true education. The regulations and program clearly states that the schools of Ontario exist for the purpose of preparing children to live in a democratic society which bases its way of life upon the Christian ideal, and further, that the school must seek to lead the child to choose and accept as his own those ideals of conduct and endeavor which a Christian and democratic society approves. The teacher is then counseled to bring home to the pupils, as far as their capacity allows, the fundamental principles of Christianity and their bearing on human life and thought. So that's a description of the Ontario public school system in the government report in 1969. So, of course, the committee called for this religious instruction to be removed from the public schools. So you have a government committee created by the government. They do the report. 3 years later, they give this report. They're saying, okay, government, we think you should remove this Christian instruction from our public schools. And the government didn't do anything. The government just left it in place. I'm assuming it was just too controversial for the government to make those kinds of moves and remove religious instruction from the public schools. And so the removal of Christian instruction from Ontario's public schools was never done by politicians. It would be done by the courts after the Charter of Rights was adopted. So in 1985, after the Charter of Rights has come into effect, there were 5 parents in the jurisdiction of the Sudbury Board of Education who started a court case to get, actually the first thing that's going to be removed here are the religious exercises. Saying Lord's Prayer, prayers or Bible reading at the beginning or ending of each school day. So in 1985, these 5 parents from Sudbury Board of Education, they launched a court case to get religious exercises removed from Ontario's public schools. Now at that time, Ontario's education regulation had this section 28.1 dealing with religious exercises. This is what it says. A public school shall be opened or closed each day with religious exercises consisting of the reading of the scriptures or other suitable readings and the repeating of the Lord's Prayer or other suitable prayers. So that was the regulation at the time. They shall be opened, with these Christian exercises. Now, it's important to realize children could be exempted from these. Like, this wasn't compulsory. If parents didn't want their children to participate, they could have their children removed. So it was not compulsory in that sense. Nevertheless, this went to the Ontario Court of Appeal, and the Ontario Court of Appeal ruled in 1988 that Ontario could no longer have these religious exercises. And this is part of their ruling. It says this. Section 28.1, which I just read to you, is antithetical to the Charter objective of promoting freedom of conscience and religion. The recitation of the Lord's Prayer, which is a Christian prayer, and the reading of scriptures from the Christian Bible impose Christian observances upon non-Christian pupils and religious observances on non-believers. So they used actually, much of their decision is based on the precedent of the Big M Drug Mart decision, which I mentioned earlier. Like the Big M Drug Mart decision said we can't have Christian influence in public policy anymore. So that was a major precedent for why we need to remove religious exercises from Ontario's public schools. So, using precedents like that, that's a completely normal thing in Canadian law. But one of the things they did was quite different here. This Ontario Court of Appeal, they also relied on a couple of U.S. Supreme Court decisions in justifying why we needed to remove religious exercises from Ontario schools. Those Supreme Court decisions in the United States were Engel versus Vitale and Abington School District versus Schempp. Now, this is significant because in 1962, the United States Supreme Court ruled in Engel versus Vitale that public schools cannot ask students to recite prayers. Like the specific case dealt with a school district in New York, and they asked students to say, a short prayer at the beginning of the school day. Again, even in that case, the students did not have to participate. They could leave or not participate. And nevertheless, this went to the Supreme Court, and the Supreme Court said, okay, no more prayers in American public schools. So this is one of the most controversial Supreme Court rulings in American history. Like, it caused an uproar. It was very unpopular, with huge majorities of Americans opposed to that, removing prayers from the public schools in 1962. Now, the companion case to that, 1963, Abington School District versus Schempp. Now, that was because there was a school district in Pennsylvania with a brief religious program consisting of Bible readings and recitation of the Lord's Prayer every day. That went to Supreme Court. Again, the Supreme Court threw that out, so you could no longer have, these Bible readings and Lord's Prayer in public schools in the United States. So when those decisions came out in 1962 and 1963, they had no bearing on Canada whatsoever. Our political system was totally different from the American system. What happened there did not happen here, but because the Charter Americanized Canada's political system, adopting the Charter was based on the American model, so now Canada's courts will rely on American precedents for some of what they do. And so they relied on these two precedents from the American Supreme Court. Now, it's really important to think about this too, that many Americans consider those two decisions, that 1962 and 1963 decisions, as a turning point in American history. That's when God was thrown out of American public schools. So these are very important decisions in the United States. And actually, you might have heard of an American Christian historian, David Barton. Like, he wrote a book about this in the late 1980s about how this was the turning point in American history, having prayer and Bible reading thrown out of American schools. And even there's a contemporary charismatic author, Jonathan Cahn. He had a book called Return of the Gods that came out just about 3 years ago. And he points out, too, in that book, he considered these two decisions to be a turning point in American history. And those decisions were a turning point in American history were imported. The jurisprudence, some of the jurisprudence was imported into Canadian law as a result of the Charter of Rights in this Zilberberg decision of 1988, throwing religious exercises out of the public schools in Ontario. Now, the companion case to the Zilberberg case was the Elgin County case, and this is where Christian instruction would be put out of the public schools in Ontario. So the Canadian Civil Liberties Association, after the Charter of Rights was adopted, the Canadian Civil Liberties Association wrote to the Minister of Education in Ontario saying, you should get rid of this Christian religious instruction in the public schools. He didn't do anything, so they launched a court case. And to make a long story short, this went to the Ontario Court of Appeal. So I read earlier to you Section 28.1 of the Education Regulation. Now I'm going to read Section 28.4. This is what the regulation said at the time. 2 periods per week of 1/2 hour each, in addition to the time assigned to religious exercises at the beginning or closing of a public school, shall be devoted to religious education. So the education requirements in Ontario public schools was to have 2 half-an-hour periods per week on religious instruction. And in Elgin County, that religious instruction was explicitly Christian. So that's why it would become the basis of the court case. So the curriculum used in Elgin County and the public schools was developed by the Elgin County Bible Club. And that curriculum was also taught by members of the Elgin County Bible Club in Elgin County. And so children were taught, among other things, that only through the blood of Jesus can sin be taken away, and that students must follow the example of Christ and believe on him in order that they might be saved. So that was religious instruction in Elgin County, up until that time. So, of course, the Canadian Civil Liberties Association took that to court, and the Ontario Court of Appeal said there's no way we can have this. They threw religious instruction out of Ontario public schools. That's 1990 when that decision was released. So from 1990 onwards, there's been really, the era of Christianity in Ontario's public schools was over in 1990. First, 1988 was Zilberberg, and 1990 with the Elgin County decision. So for, well over 150 years, Christianity has been an essential part of public education in Ontario, and it was thrown out as a result of the charter, court decisions based on the charter. Now, these were Ontario decisions, but the effect went into other provinces as well, especially that Zilberberg decision. After the Zilberberg decision was released, there was a court case in British Columbia and a court case in Manitoba where parents were challenging the religious exercises in the public schools. And in both those provinces, the courts relied on the Zilberberg precedent to put religious exercises out of those provinces, out of BC and Manitoba. So as one legal scholar has written, the Zilberberg case constituted a fundamental benchmark in Canadian jurisprudence. Even though it's not a Supreme Court decision, it has influence right across Canada. Now, there's a strange footnote to this, and that is that decision has no effect in Alberta and Saskatchewan. Canada has this is kind of a footnote, but Canada has this really strange constitutional system called asymmetrical federalism. So some provinces have rights and jurisdictions that other provinces don't have. So it's kind of a quirky thing, but when Alberta and Saskatchewan became provinces, part of their addition to Canada as provinces in the Constitution was that their public schools retained the right to have the Lord's Prayer said in their public schools. So the Zilberberg decision applies for sure to Ontario, Manitoba, and BC, and probably some other provinces, but not to Alberta and Saskatchewan. Now, it's unlikely that having public school children recite the Lord's Prayer does any real good. But the constitutional protection given to the Lord's Prayer in Canada's Constitution for Alberta and Saskatchewan is a firm institutional reminder of this country's Christian foundation. Only a Christian country would have the Lord's Day written into its Constitution, even if it's just for certain jurisdictions. Okay, so far I've talked about the Lord's Day Act and Christianity in Ontario public schools. So my final example is marriage in Canada. Right, until 2005, when the Parliament changed the definition of marriage, marriage in Canada was only between a man and a woman. And actually, Canada's official definition of marriage until 2003, when it was struck down by the Ontario Court of Appeal, was based on a British court decision, Hyde versus Hyde in 1866. So from before Canada was an independent country until 2003, our definition of marriage was an explicitly Christian definition of marriage. Let me just read this definition of marriage for you. Marriage, as understood in Christendom, may for this purpose be defined as the voluntary union for life of one man and one woman to the exclusion of all others. So our official Canadian definition of marriage started out, marriage as understood in Christendom. So the word Christendom was right in our definition of marriage until 2003. So in the early 2000s, various gay rights groups launched court cases to strike down, to have the courts strike down Canada's definition of marriage. There's court cases in BC, Quebec, and Ontario. Now the most important one was the Ontario one, which is called the Halpern decision in 2003. And so the question was, does Canada's definition of marriage violate the Charter of Rights? And the Ontario Court of Appeal ruled yes. Canada's historical definition of marriage violates the Charter of Rights because the Charter of Rights guarantees equality, has equality guarantees, and having a definition of marriage that only included, that required one man and one woman violated the equality of homosexuals. And so they rewrote the definition of marriage to be the voluntary union for life of two persons rather than of a man and a woman. So from June 10th, 2003, when that decision was rendered, Ontario's definition of marriage, included same-sex couples. Some of the other provinces changed their definition as well, but then finally, in 2005, Parliament did the official change for the whole country with the definition of marriage. But the Parliament's change of the definition of marriage in 2005 was prompted by the court decisions, especially prompted by the Halpern decision. They are pushed in that direction by court decisions based on the Charter. Now I'm just going to address, again, what I mentioned earlier, the word God in the Charter's preamble. So the preamble to the Charter of Rights says this: whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. So many Christians think that makes the charter Christian, and like I sympathize to that because it was because of Christian lobbying that the word God was put in the preamble. Like Trudeau did not actually want the word God in the preamble, but Christians were campaigning for it, and he wanted to expand the popularity of the charter idea. So he was told if they put God in the preamble to the charter, that would get evangelical support for the charter of concept. And so that's kind of how it got in there. But Christians were hopeful about that we had God mentioned in there. But the problem is that Christians assume that the word God, G-O-D, in the preamble to the charter is our God. Like we assume that's our God. But that's not actually how it's turned out. Like if you read section 27 of the charter, now this is, section 27 of the charter says this: "This charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians." So that's important because the charter has to be interpreted in light of Canada's multicultural heritage, like not our Christian heritage. It's not to be interpreted in light of our Christian heritage. It's to be interpreted in light of our multicultural heritage. So it's a multicultural God, that word G-O-D in our preamble, it's a multicultural God. It's a God that represents all kinds of beliefs and religions. The charter's God is not the God of the Bible, but a generic God that doesn't offend anyone. It's a multicultural God, a God suited for all religions. So it's not the Christian God. And again, let me just read a quote that I previously read from the Big M drug mart decision. This is what the Supreme Court said about God in the preamble. Like this is one of the very first charter decisions. "The evolution of Canada as a pluralistic multicultural society, as well as the reference to God rather than to an identifiably Christian conception of God, can have no bearing either on the characterization of laws aimed at enforcing specifically Christian observances, nor on the classification of such legislation as being within Parliament's criminal law power." So they're contrasting God with the Christian conception of God and saying the God in the preamble is not the Christian conception of God. Now this again, a few years later, was some guy attempted to litigate this again. Like in 1999, there was a case dealing with child pornography, and a Christian lawyer in BC, R.W. Staley, he was representing the Evangelical Fellowship of Canada and focused on the family. He tried to litigate something against child pornography by reference to Canada's Christian heritage with the supremacy of God mentioned in the charter, but the judge wouldn't bite. This is what the judge said: "I know of no case on the charter in which any court of this country has relied on the words Mr. Staley invokes. They have become a dead letter. And while I might have wished the contrary, this court has no authority to breathe life into them for the purpose of interpreting the various provisions of the charter." So even this judge in 1999 said that those words in the preamble, they're a dead letter. Like no court has ever interpreted it the way this guy wanted it to be interpreted, like using the word God to argue for Canada's Christian heritage and laws in that perspective. Now the charter was adopted in 1982. I just had one major point here yet. The charter was adopted in 1982, but the governments were given 3 years to change their legislation in conformity to the charter before it actually came into effect. So it was adopted officially in 1982. Most of the provisions came into effect in 1985. So it was a 3-year period. They didn't want, if they adopted it completely in 1982, then there could be immediately court decisions or court cases initiated against all kinds of legislation. So the governments were given 3 years. Change your legislation to conform to the charter during this 3-year period, so we don't have a rash of court cases, immediately. So in 1985, the Charter of Rights is about to become, full force in Canada. And our Minister of Justice at that time was John Crosbie. Like we had Brian Mulroney's government at the time, so John Crosbie was the first Justice Minister. So John Crosbie gave a warning to Canada. Like he was a Justice Minister. All these people are talking to him. Okay, the Charter's coming into effect. He's the top guy in the government responsible for that. So this is what he said. John Crosbie said this publicly in 1985. "The public does not realize that we already have had a revolution in Canadian society. The adoption of a charter was a revolution. It has changed the whole power structure of Canadian society. It has taken tremendous power from governments and given it to the courts of Canada, the Supreme Court of Canada, which is not widely realized. Not only can they strike down our laws now, but they say they can challenge policies adopted by the Cabinet and so on. Therefore, we are in a whole new legal environment in Canada. There has been a revolutionary change." A revolutionary change. It was not sold as revolutionary change, right? It was sold as you want your rights entrenched in the Constitution. But here's the Justice Minister of Canada, our top law officer, saying, wow, this charter's coming in. We've had a revolution in Canada. The adoption of the charter was a revolution. And he was exactly right when you look at what the charter has done to Canada, in terms of some of the things I've talked about tonight, or this morning. So, just to conclude then, Canada was once a Christian nation, but that's no longer the case. Among the factors contributing to Canada's abandonment of Christianity was the adoption of the Charter of Rights in 1982. The Charter is not the sole cause of the problem. Canada was already abandoning Christianity before the Charter came along and would likely have continued along that trajectory even if the Charter had not been part of the Constitution. Nevertheless, the Charter has had an unmistakable effect of pushing Christianity out of the public life of Canada. Like it gave the enemies of Christianity a political tool that they could use, a constitutional tool for removing Christianity from public policy in Canada. It gave them a tool, and they used that tool vigorously in the courts to remove Christianity from Canada's public policy. So any attempt to repeal the Charter right now would be unreasonable. The Charter is entrenched in a constitution that is almost impossible to amend. More importantly, it has burrowed its way into the hearts and minds of most Canadians, at least if the polls are to be believed. So I'm not going to propose repealing the Charter right now. Like that's a non-starter. That's not going to happen, anytime soon. So the Charter is currently the Constitution, so Christian lawyers must rely on it in court cases despite its problematic nature. As you can probably figure out, I don't like the Charter. I think it's bad. It's harmed Canada. But Christian lawyers today still have to use it because that's what we have. That's the only tool they have. So, I don't begrudge them for using the Charter because they don't have any alternatives. So our situation, actually, Stephen referred to this earlier, like our situation in Canada is increasingly like that of Christians in the Roman Empire with a hostile culture and government. Like it hasn't reached the point of violent persecution, but it's going in that direction. We need to be faithful as Christians and trust that God will use our prayers and actions to achieve positive change. And actually, to finally conclude, I just want to remind you all what Pastor Wilson said last night. Like, my conclusion would be like what he said. That's the solution. That's the solution to our problem as in Canada with our Charter of Rights and so on. Like he gave the solution that we need to look to, and that's the only way we'll have positive change within Canada. Thank you. Actually, I have written a book. If you're interested in this topic, like I just gave a very brief summary of this book, Leaving God Behind, the Charter of Rights and Canada's Official Rejection of Christianity. So I wrote that in 2012. So this has all the documentation with much more information than what I talked about just now, in case you're interested. Thank you.